At your arraignment, a prosecutor can move for 58A, or pretrial detention without bail. If a prosecutor moves for a dangerousness hearing, that hearing is usually not held at the arraignment, although it can be. Usually it's held a few days later. They can call witnesses or present evidence. You can present evidence in response. You could call witnesses, although generally you hold off as a defendant because you don't want to show your hand. Sometimes the prosecution goes forward on papers alone. They'll submit police reports and rely on just documents. At a 58A hearing, the prosecutor has to convince the judge by clear and convincing evidence that not only are you a danger, but also that there are no conditions of release that would ensure the safety of the community or of a specific victim in your case. Oftentimes, the counter to that is that there are conditions of release that would ensure the safety of the community or of a specific person. We often suggest a GPS bracelet, or hours of curfew, or even home confinement. Sometimes we suggest a large cash bail rather than being detained. It's vital that the attorney does everything he or she can to get you out at the 58A hearing, because it sets the tone for the case. It makes communication easier between attorney and client. It makes a huge difference in the case if you can get out at the 58A hearing versus being held. Even though the time limits are 120 or 180 days, depending on district or superior, those deadlines really don't mean what you think they do. Those are often extended. There are excludable periods of time that don't even count towards the 120 or 180 days. So often what that means is that somebody's actually held in jail until the point of trial. If you're in district court and the judge ends up holding you as a danger, you can appeal to the superior court. And I've had a lot of times when a superior court judge will overturn the district court judge and let somebody out on conditions of release. If you're in superior court and you get held, you can petition a single justice of the Supreme Judicial Court to reevaluate that detention order.